I'm sorry. Your Honor.
Apologize. Mr. Take the jury, please.
I'm so sorry, Your Honor.
No, it's not you. It's not you. Take the jury, please. Ms. Lundy, everybody may be seated. And I apologize for interrupting you in the middle of closing.
I'm
The
terribly.
behavior from him, from Mr. Bloom, I am not going to have in terms of his gestures, his noise and everything, particularly behind Ms. Lundy's back. Not going to have it. Mr. Burnton, I'm going to give you a chance to talk to your client about it and tell him that he is to sit there quietly or not at all.
Watch what happens here. The judge stops the closing argument, clears the jury, and then warns the defendant to sit quietly or get removed. And then the defendant chooses to walk out of his own trial.
Calls the case of the People versus Jeffrey Bloom.
After the people.
Good afternoon, Mayor Sam Bernstein with and on behalf of Mr. Bloom.
And as I've apprised counsel, during the course of the trial, Mr. Bloom, I don't know, and I'm going to assume that at least for these purposes that you weren't doing it intentionally. There have been comments which I could hear all the way up here, and I'm sure the jury could hear it during the course of these proceedings. That then, when Ms. Lundy got up to give her closing argument, there were additional comments. I didn't do anything about that, but the moment the gyrations with your hands occurred behind her back, I stopped the proceeding. I'm not going to tolerate any of that.
This is the moment that matters. The judge isn't reacting emotionally. He's building a clean record. He's explaining why he stopped the trial and what he observed and what behavior crossed the line. That's protection against appeal. Once the judge starts narrating like this, the consequences are already in motion.
I will stop it again if that's what we have to do, but I'm going to admonish you and warn you at this time that the court is not going to allow that type of conduct to occur. With that admonition, Mr. Bernstein.
I was going to say there were some times where Jeff was speaking with me during the trial.
Oh, I understand that, but there were other points at which there were just extraneous comments. So I was letting those go, but I'm not going to have that and have counsel interrupted during the course of their closing arguments. With that admonition, are the parties ready for the jury?
Your Honor, I also understand there's been information given to the jury that.
Correct. Yes, for the purposes of the record, I did inform counsel. So at no, that the jury did not take that in any way to be applicable either to Mr. Bloom or to the people, because I had stopped Ms. Lundy in the middle of her closing argument. And I had indicated that they are not to take any delay or interruption by the court. They are not to attribute it to either party. They are to attribute it to the court of its own doing, so that the jury understands that and does not hold that against the people or against the defendant.
Thank you, Your Honor. I am ready to proceed.
Is the defense ready?
I am ready, Your Honor.
All right, let's bring the jury. What is going on? All right. Go ahead. Thank you.
Still hot mic.
Oh.
Is he ready to, what's? Pardon?
I don't think he wants. Sick, Your Honor.
No.
Yeah. Did you want to go back there and try to talk with him? Because in the record should reflect, if it doesn't already, that after the court's admonishment to defendant and asking whether or not the people in defense were ready, that the defendant on his own accord, decided that he would leave the courtroom.
This is huge. A defendant has the constitutional right to be present, but he also has the right you can voluntarily give up. That's why the judge slows everything down here. He's making sure that the record is straight before he decides how to proceed. This isn't drama. This is procedural survival.
I've been informed by transport that it appears that he does not wish to come back out.
I really should try to speak with him, Your Honor. I mean,
Yes, you should.
it's a significant right to be at your own, like in the Constitution or something.
One which one can, I believe, voluntarily forfeit.
That's fair too. Yeah.
So before we get to that stage, I'll stand in recess and allow you to have an opportunity to chat. All right, thank you. All right. Ladies and gentlemen. Yeah, Alan's trying to put the jury out, so. All right. Okay, we're back on the record. Court does recall the case of the people of the state of Michigan versus Jeffrey Bloom. Counsel, state your appearances.
Ashley Lonnie for the people.
Sam Bernstein for Mr. Bloom, Your Honor.
All right, Mr. Bloom is not present. If I say anything incorrectly, please, counsel, correct me. Just prior to our last recess, when we were trying to continue with the trial, after the people had begun their closing argument, I stopped the proceedings, gave an admonishment, had the jury removed, gave an admonishment to the defendant regarding comments that he was making, as well as gestures in terms of his hands, because of the positioning of the podium behind the prosecutor's back. Gave him that admonishment, then told him that I would not tolerate any of that behavior. At that point, I did not hear anything, or at least nothing that was audible or understandable from the court in terms of the defendant saying anything. The defendant got up and he removed himself from the courtroom. Transport took him back. I took a recess in order to allow Mr. Bernstein to speak with his client. I was then informed during the course of that from transport that Mr. Bloom did not wish to return to the courtroom. And so that's kind of where we were left. The question that arose as to whether or not this court, given the defendant's behavior, whether or not this court could continue with the trial, even though we just had closings and the verdict to go.
If you want real courtroom turning points, not commentary hype, subscribe to Bench Breakdown.